reimbursements. All right, everybody ready, or do you need a minute? We're good? Good afternoon. This is a press availability in light of a very important decision of the Pennsylvania Supreme Court that was just released in the case of Commonwealth versus Derek Lee. We're going to get into some of the specifics, but understand the big picture here. There are over 500 Philadelphians who are doing sentences of life without the possibility of parole as a result of a law that said for second-degree murder, the only possible sentence would be a mandatory sentence of life without the possibility of parole. Pennsylvania Supreme Court has ruled today that that law is unconstitutional, which throws into question whether any of those 500 plus people are going to be actually facing a sentence of life without parole, which has been their expectation in some cases for decades. That is part of the big picture. Another part of the big picture is there are undoubtedly a lot of survivors, co-survivors, who sat through a trial a long time ago, left with the clear understanding that the outcome of the case was a sentence of life without parole, and that understanding is no longer clear. The decision itself is lengthy. It's about 70 pages. It involves 5 different opinions by justices of the Pennsylvania Supreme Court. And it is not the ending, it is a beginning. What it says, among other things, is that the legislature will have 120 days to try to figure out next steps. And if the legislature does not pass laws that will direct these next steps, then today's opinion will go into effect. In addition to that 120 days in which the legislature has the opportunity to do something, there are other questions that have not been answered yet, although we expect that they will, and in fact they must be answered one way or another as we move forward. What are they? Well, the first one is retroactivity, meaning, does this decision apply to the 500 plus people who already got a sentence of life without parole and have begun serving it? There are certainly some other questions about the process that might be followed in order to do resentencings. And then, of course, there is the question, much like there was when the famous ruling determining that mandatory life for a juvenile for a first-degree homicide case was unconstitutional, there may be legislation that comes up with a sentencing scheme for second-degree murder moving forward. It remains to be seen what that is. Without further ado, I'd like to recognize some of the people who are here. They are the ones, unlike me, who have dug through every word of this opinion, and they are the ones whose careers have been spent addressing post-trial issues in one way or another, and I think they're the best equipped to get into some of the details here. I have standing up here with me Jen Lynn, Chief of Staff, Cheryl Yankalonis, Trial Deputy. We have Steve Weilberger, who is one of the supervisors of the Law Division. We also have with us Pete Andrews, who is one of the supervisors of the Law Division, here in spirit, although not visibly in suits. We have Katie Ernst and Dave Napiorski, who is at this time the Chief of the Law Division, all of whom have spent a few hours poring over this. Final point before I let them come up and talk, this office supported this ruling. We filed an amicus brief agreeing that the sentencing scheme was unconstitutional, and our position on that, not necessarily the traditional prosecutor's position, which seems to have a default of everybody sit in jail forever, but our position on that has been vindicated and supported by a Pennsylvania Supreme Court consistent with a long history of saying that people have more rights in Pennsylvania under the Pennsylvania Constitution than they have under the U.S. Constitution. That is a very long tradition and has a lot to do with the reality that the framework, as they call it, the original Pennsylvania Constitution, became the template for the U.S. Constitution and was based profoundly on the personal experience of William Penn, who was oppressed in England for his religious beliefs, subjected to a trial that looks nothing like the trials that we have in the United States, and tried to build in the lessons of that unfair treatment, build them into the Pennsylvania precursor Constitution, which then was used as a model for the U.S. Constitution. Anyway, before I get into my historic ramblings, I just want to point out that this office, because Philadelphia had more juvenile lifers than any city in the world, this office went through more than 200 resentencings of juvenile lifers. It was a Herculean effort. It took a period of years. We did far better than other jurisdictions. It was completed at the end of the Seth Williams administration and during the first, it was almost completed. There are a few stragglers, but it was almost completed during the first few years of this administration. The prospect of facing over 500 potential resentencings, I mean, it's very doable, but it does require the dedication of a lot of time and a lot of resources to make sure that we do justice in these cases and that we do individual justice, which is a fundamental point of this opinion by the Pennsylvania Supreme Court. The fundamental point is that justice should be individual, not mechanical, not robotic. This is another important opinion that goes against the simplistic, unjust view of mandatory sentencing as being a good solution on criminal justice issues. At this time, I'm going to invite my colleagues from the Law Division to step forward, one or many, and to explain further some details. After that, we will go to Q&A.
Thank you, Mr. District Attorney. My name is Peter Andrews. I'm the supervisor of the Federal Litigation Unit, which is part of our Law Division. I'm briefly going to just put this ruling in some context and then talk about what we expect may happen going forward. Today this is a significant and important ruling. It's a step that, as the District Attorney mentioned, our office asked the Pennsylvania Supreme Court to take, and I want to specifically acknowledge our team that worked on the front of the court brief in the Pennsylvania Supreme Court, which was led by our supervisor, Dave Napiorski, as well as Steve Wildberger, Catherine Ernst, and others. This ruling affirms a really important principle, which is that the Pennsylvania Constitution is in many ways more protective of individual rights than the federal Constitution. And that's very important in an era like we're seeing today, where the Supreme Court has taken certain view of the law in recent years. The Pennsylvania Supreme Court is not bound by what the Supreme Court says when it comes to interpreting the Pennsylvania Constitution. And what they've said here is that in the case of a defendant who's convicted of second-degree murder, which means that they didn't have the specific intent to kill, that a mandatory sentence of life in prison without the possibility of parole violates the Pennsylvania Constitution because it is a cruel punishment. And what we expect will happen going forward is that courts will have discretion in setting minimum sentences for second-degree murder, where the defendant will now have a parole eligibility date at some point. Giving this discretion back to the judges is, as the District Attorney said, an important step as we try to sentence each defendant individually for their individual actions. An important question that's left open by this opinion is what's going to come next and how soon it's going to come, because the numbers that we have are that as of April 2024, we estimated that there are about 500 defendants serving second-degree murder sentences out of Philadelphia. So that number may have shifted slightly over the last 2 years, but that's about the number. And the question is what's going to happen to those people. The Supreme Court today left open the question of retroactivity, which means essentially, does this apply to people whose convictions and sentences are final and no longer have the ability to appeal? They left that question open because they wanted to give the legislature an opportunity to set up a scheme within the bounds of their opinion today. We're not going to predict what the legislature is going to do, but in 4 months this opinion will take effect, and state defendants will have the opportunity to challenge their sentences and essentially make a claim that this should affect them even if they were sentenced many years ago. We expect that that issue will probably make its way back to the Pennsylvania Supreme Court again, and we think that could take anywhere from 4 months to 18 months or 2 years. If the Supreme Court holds that that opinion is effective on retroactive review, then we expect a process to take place like with the juvenile lifers, where folks get resentencing proceedings. But at this time, that's many years down the road. So we're in a waiting period because the opinion gives the legislature time. We will continue to carefully review the opinion and take all appropriate steps to make sure that defendants, victims, everyone in the city of Philadelphia gets the justice that they deserve. That's all from me.
All right. On that note, there's a lot more wisdom up here if you have questions. But on that note, we will shift to any questions. Mr. Alan Wheeler, Channel 3 CBS. Do you have any questions, sir? No questions. Thank you. Jillian Kramer, Philadelphia Inquirer. Do you have any questions? Great question, and the short answer is yes. We routinely deal with situations where you have an older conviction, often on a really serious homicide case, and due to the discovery of Brady material, meaning material helpful to the defense that was not turned over by the police or by a prosecutor, that conviction is about to be overturned. It's always a difficult and sensitive situation, but we reach out vigorously to these families because they need to be heard, or at least they need to tell us that they don't want to participate in being heard. That has been going on forever. The only difference here is this is a lot of people. In some ways it may be a favor that there's a 4-month wait until we are going to see whether the legislature has moved forward. In some ways it may be a favor that there's going to be additional time in the process to determine issues like retroactivity and things of that sort, because it does allow us to get a head start. I intend to direct, now that we have an opinion, we've all been waiting for this for quite some time, but I intend to direct our victim witness services staff to start reaching out in the most logical order to inform people. But the truth is, there's a limited amount that we know now. We'll know a lot more in 120 days. It's a lot of work to go and try to find viable phone numbers, contact information, addresses, et cetera, for cases that are 40 years old, 45 years old, even 15 years old. It can be a lot of effort, but that effort starts now, and we will vigorously pursue it. I'm not going to wait for 120 days. We're going to get started. Do you have any other questions? All right, Sherry Stone, Philadelphia Tribune. Can I think of an example or two? Well, my recollection of that case is it involved convictions of third-degree murder. I do not believe, and I'm just working from memory now, we only handle 35,000 cases a year, but working from, actually more, but working from memory, that was a case in which there were 3 people who died in that horrific accident. There were convictions on third-degree murder, so this case would not affect that. However, you know, the classic second-degree murder case is a robbery gone bad, as they say. It's a case where you may have a minor participant, or you may have a getaway driver who were all down for the robbery, but didn't believe that there was going to be a homicide coming out of it. That is a very common fact pattern. We've seen it many, many times over decades, and I'm about 4 decades into my career. So it will affect a lot of cases, recent ones, very old ones, and everything in between, where a scenario like that, which is an often unanticipated death in the course of a felony, has occurred, and there is a conviction not on first degree, but on second degree. Do you have any other questions, Ms. Stone? Okay, Dan Horan, Philly FPV. No questions. All right, well, thank you all. And with that, we will keep moving. I did get everybody, right? I did. Okay.